Hello. Thank you so much for joining us today for a discussion about the Supreme Court's recent ruling on affirmative action and what it means for students and universities. My name is Seth Maskett. I'm a professor of political science and director of the Center on American Politics here at the University of Denver. The center occasionally hosts discussions about important and emerging issues in American politics, and this recent decision seemed like it warranted such an event. Just last week, the U.S. Supreme Court ruled in the case of Students for Fair Admissions Incorporated versus President and Fellows of Harvard College that colleges and universities can no longer, use race solely in the process of admissions for universities. To get a sense of what this all means, we've invited some of the leading scholars on this topic from across campus. And I am going to introduce those scholars now, and we'll start our discussion. We have with us first Sarah Chatfield, who is an assistant professor in the Department of Political Science at the University of Denver. Her recent book, In Her Own Name, The Politics of Women's Rights Before Suffrage, explores married women's economic rights in the decades before the 19th Amendment was ratified. She teaches classes on women in U.S. politics, constitutional law, and judicial politics. We also have with us Alan Chen, who is the Thompson G. Marsh Law Alumni Professor at the University of Denver Sturm College of Law, where he teaches and writes about American race. Excuse me, I'm having some problems with my notes here, about race and constitutional law. He is also the co-author of 3 books and numerous scholarly articles about a wide range of constitutional law topics, and is also a practicing attorney in constitutional law cases in federal courts around the country. Finally, we have D.L. Stewart, who is a professor and chair in the higher education department at the Morgridge College of Education here at DU. Their scholarship and teaching focuses on the experiences of college students minoritized by race, sexuality, and gender identity, and the uses of diversity, equity, and inclusion by colleges and universities. So I will start with some questions for our panelists about an area of public policy that is a rather large departure from the past. We'll try and get a sense of what's going on here. After that, I will turn to your questions if you have any. If you do have questions during the course of this conversation, please feel free to use the Q&A button at the bottom of your Zoom screen, and we will do our best to get to those before the hour is up. So I would like to start by turning to Sarah Chatfield. Sarah, if you could, can you give us an idea of what exactly the court ruled? That is, how is this different from prior rulings on affirmative action, on quotas, et cetera? What is distinct about this moment?
Thanks, Seth. And thanks to the Center on American Politics and all of their staff for organizing this event. So this case dealt with a challenge to admissions practices at Harvard and the University of North Carolina. Both universities, like many of the elite selective universities in the United States, used race as one factor among many in making admissions decisions. This is also commonly known as affirmative action policies, but it's important to note that affirmative action policies could operate on any number of identities or factors. These challenges only dealt specifically with the use of race in admissions. The Supreme Court ultimately struck down both policies from Harvard and UNC, and the decision was along ideological lines. In the UNC case, the vote was 6-3, with the 6 conservative justices voting to strike down the policies, the 3 liberal justices voting to uphold them. In the Harvard case, the vote was 6-2. That's because Justice Ketanji Brown Jackson recused herself due to having previously served on Harvard's Board of Overseers. But ultimately, the reasoning was really the same for both universities. The majority ruled, and this was written by Justice John Roberts, that race-conscious admissions policies violate the 14th Amendment's guarantee of equal protections. So Seth, you'd earlier mentioned the idea of quotas. This is the idea of specific racial targets in admissions. That actually hasn't been allowed since 1978. But previous Supreme Court rulings, I think Alan is going to talk more about these in a minute, did allow the use of race as one among many factors in a holistic admissions process with the purpose of creating a diverse student body. And Justice Roberts is particularly concerned that these race-conscious admissions practices use race as a quote-unquote negative, that is penalizing some students for their racial identity, and as a stereotype. So assuming that all students of a particular racial background might have similar experiences. He's also concerned that universities have not identified a specific endpoint or stopping point at which they would end the use of race-conscious admissions practices. Interestingly, in a short footnote, Roberts seems to exempt military academies from the ruling, saying that they have these potentially distinct interests from other types of universities. It doesn't really go into explaining why diversity in, say, an officer corps is more important for the military as opposed to economic and political halls of power. I think that's going to be something interesting to watch in future cases. Justice Roberts does state that universities could potentially consider in applications, quote, an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And Harvard has already seized on this language in their sort of PR, public communications about the case. I think DL is going to talk more about sort of what types of policies this case may leave open in the future and what that could look like for universities. And I think we're going to also talk about the dissents in the case a little bit later, but that should give sort of a brief overview of the major points from the majority.
Thank you so much, Sarah. That's really helpful. Alan, I would like to turn to you next to go in a little bit more detail on this. On what basis did the court reach this decision, or these two decisions? Were these rooted in some sort of precedent? Was this an overturning or an abrogation of precedent? Were they just kind of making things up? Like, what's your sense about the background here?
Those are great questions with unclear answers. Because the court's decision by Chief Justice Roberts is a little bit cryptic about exactly what it's doing. So I think to be fair and reading through the opinion, I would say that the Chief Justice avoids saying the quiet part out loud, which is that they've effectively overruled affirmative action in higher education admissions in all but the most unusual cases. And so they've effectively overruled the prior decisions in Fisher versus University of Texas and Grutter versus Bollinger and Regents of the University of California versus Bakke, all three of which are prior Supreme Court decisions over the last 50 years that have recognized that the consideration of race as one factor among many, many different factors in an applicant's profile was previously permissible, even though it explicitly took race into account as one of these factors. As Sarah pointed out, in these previous cases, the Supreme Court has said, well, as long as race is not the determinative factor, but is a consideration in sort of composing the entering class at a particular school, that doesn't violate equal protection. Even in the prior cases, the court has applied what is known as strict scrutiny, which is the highest level of skepticism by the court that a democratically elected policy should be subject to harsh scrutiny, because of the idea that in the past, we don't trust the government to make race-based decisions in most contexts. But even applying this high level of scrutiny in the Grutter versus Bollinger review in the University of Michigan Law School's affirmative action program, the court held that race could be a consideration because it withstood that difficult standard. And what the court said in Grutter was there is a compelling governmental interest in higher education institutions promoting diversity in their entering classes in order to provide educational benefits for all students. In other words, the experience of all students is affected by the composition of the particular classes that they take. They interact with. If you have a homogeneous class where everybody comes from the exact same economic, religious, racial, cultural backgrounds, as we all know as teachers, the discussion is going to be kind of boring, right? There's going to be no different perspectives to be offered, and the court recognized that in Grutter as a compelling enough interest to permit affirmative action in that case. Here, applying the exact same standard, or at least purporting to apply the exact same standard, the Supreme Court said no. Even if we accepted the idea in the abstract that diversity in higher education is a compelling governmental interest. The majority opinion by Chief Justice Roberts here says, well, but those are kind of fuzzy. Those are not really concrete enough determinations. Like, how are we supposed to, we as a court supposed to measure whether the university has a compelling interest in advancing leadership skills among different groups of students, better educating students through diversity in the classroom. And what the court basically said is, what we said in Grutter, we no longer believe is true, because we as a court can't measure whether those factors are concrete enough to meet this compelling interest standard. Effectively, what this means is no university will be able to prove this difficult standard the way that the court agreed that the Michigan had in the Grutter case. The other thing, as Sarah mentioned, is that the court really sort of thinks that the use of race as even one factor among many violates the Equal Protection Clause, as well as Title VI of the federal civil rights laws, which apply to private universities receiving financial aid, because both universities, Harvard and UNC, used such broad definitions of racial categories as to perpetuate what the court considered to be different stereotypes, or to be not sufficiently tailored or to address the types of diversity that they claim to be pursuing. So it is really an abrogation of the precedents that the court has decided, even without saying so explicitly. Justice Thomas and the three dissenters both all acknowledge that the court has effectively overruled Grutter. So.
Thanks. That's really helpful. Thank you for clearing that up. DL, I would like to turn to you on this. I have a question about really how many schools, how many students this ruling affects. That is, there's been some discussion how affirmative action is mostly in play in the more selective elite schools. Does it apply well beyond that? What kinds of schools are most affected by this? And then more generally, how will this affect a student of color applying to college next year?
Yeah, thank you so much, Seth, and thanks also to the Center on American Politics for this opportunity to share and to be part of this collective brain trust here this afternoon. And then you ask a really important question, and it's important because in some corners of the public sphere, the dialogue around this makes it sound like every single college in the U.S. uses affirmative action, which could not be further from the truth. There are over 4,000 institutions of post-secondary education in the United States. This decision affects about 200 of them, right? It's really only institutions whose selectivity is at the highest level, right? So we're talking institutions that admit maybe around 20% or less of their applicants, that need affirmative action. And they need affirmative action because the general criteria that they're using has been shown repeatedly over time through research that they discriminate and are biased against, particularly in terms of race, folks of color. They're also usually biased against lower income and working class folks, students with disabilities. There's a whole echelon of bias and discrimination that goes along that makes these admissions decisions not meritorious, right? Not really based on merit at all. And so it's those very few institutions for whom this matters. Now, in terms of the number of students that attend those institutions, just writ large, not even breaking it down by race or ethnicity, the number of students who attend post-secondary education in the US at institutions who use affirmative action are also in the very small percentages. The vast majority of students who go to post-secondary education of any level in this country attend an institution who does not need to use affirmative action. Okay, they don't need to use it because they admit 60%, 70% or more of the students who apply. Okay, And this is even acknowledged actually within, buried in a footnote in the majority opinion. It says, 3 out of 5 institutions don't use race. And what's not said there is that they don't have to, because they admit the vast majority of their applicant pool. So there's the numbers of institutions and the numbers of applicants that this really impacts is very, very small in the global scheme of things. That doesn't mean that this doesn't matter, right? This still very much matters because of the ways that merit, as Lonnie Grenier of blessed memory has writ about, that there is no such thing as meritocracy, right? And so the people who are in places of power in economics and politics and law, in education, come out of overwhelmingly these very small set of institutions, right? And so it does matter who gets to go to them, right? What difference does this make for a student of color who is applying for college admission for fall of 2024, right? So that's the other thing buried in a footnote, I think, in Kavanaugh's concurrence, is that this begins with the college class graduating in 2028. So fall of 24 admissions. What's going to look different depending on where they're applying, right? So the majority of students of color are not applying at these this number of 200 institutions. So the typical average student of color is probably not going to see a big difference because the institutions that they're applying to aren't affected by this. Students of color who are applying to institutions that do need to use it, I would presume the University of Denver would be one of those institutions, right? They are going to see some differences perhaps in if an institution had been asking specifically about diversity, right? And their experiences with diversity. That question is probably not going to be there as a prompt for them to answer, right? They are still going to be asked to self-identify if they choose to by race and by gender. That's not going anywhere, okay? The only difference is going to be on the back end that the student wouldn't see anyway, right? Is that that's not going to get factored in to the admissions decision. So there might be some changes to essay prompts, perhaps, to try to take advantage of the window that Roberts kind of left open and the majority opinion left open, as Sarah mentioned, that, you can say it, the student, the applicant can talk about it, but the institution cannot ask about it, right? And so there may be ways that the personal essay prompts may shift. But I think it's really important to be clear that this decision is about admissions. It's not about financial aid. It's not about student support services. It's not, there's things that Liliana Garces, who's a higher ed legal scholar, warns about repressive legalism. And basically it's the overcorrecting, right? And I think that that's probably the biggest danger that I see coming up, is institutions overcorrecting to make sure they, out of fear of getting sued or out of fear of being out of compliance, that they overcorrect and go beyond the actual 4 corners of the decision.
Thank you for that. I'd actually like to ask, get a little more specific on some of this material about the immediate impact of these decisions on schools like on the University of Denver and similar schools. In the wake of the ruling, our own chancellor, Jeremy Haefner, put out a statement saying, in part, quote, race-conscious decision-making is just one of many tools the University of Denver uses to ensure a diverse student body, unquote. I'm curious what you see as, possible changes to policies, how different, how things will look different in the future. In particular, there's been some discussion in the media about the use of what are called adversity scores in applications. And I was hoping you could give us a little bit of an idea of just what that looks like.
Sure, I'll do my best. I think Alan said earlier, all of this is rather kind of murky in some ways, and it's murky by intention, I think, or murky by design in a lot of ways. There are, and the chancellor is correct, there are numbers of different tools, different strategies that institutions can use, have used, and should continue to use to recruit a more diverse applicant pool in the first place, right? So how do we get more diverse students, racially, ethnically diverse students, to apply to these institutions to begin with? That starts with where are you recruiting? How are you making connections? How are you showing up in community? What high schools are you going to? Are you relying on the same high schools you've always relied on, that come from the upper echelons of socioeconomic status in predominantly white neighborhoods, right? So there are lots of ways to connect in with civic organizations, making connections with, like I said before, high schools that are not the typical high school that you used to recruit at, to bring students into the applicant pool, right? There are also measures that could be used in terms of financial aid, right? And opportunities to help yield students, right? So that's the other thing, is that admitting a student doesn't necessarily mean they're going to be able to come. If they can't, if admitted them and you've not given them the requisite financial aid to make it feasible and affordable for them to attend, they're not going to show up, right? So there's all of these things that bookend the actual admissions decision. Who's actually in the applicant pool? How do you pull them from the admitted bin into, yes, I'm actually going to come because you've made it feasible for me to come, right? And I think that institutions will hopefully lean into more innovative tools than they've used in the past. I think there have been, in some cases, just some reliance on, if you build it, they will come, kind of field of dreams kind of philosophy, that would suggest that if we just put them all in the same place, then that's all we need to do. When the reality has always been that there needs to be more than that happening, okay? Particularly if we want to realize the educational benefits of diversity that the court, the majority opinion, at least, decided to become very critical of this time around.
Thank you for that. Alan, I'd like to come back to you. So after the ruling last week, President Biden said, quote, "We cannot let this decision be the last word," unquote. I'm just sort of curious what could be seen as possible political remedies or political pushback to this ruling. Are there things that schools, that state legislatures, that the White House could still be doing to promote diversity and inclusion at universities?
Sure. In some senses, the writing's been on the wall for this decision for quite a while. The major thing that happened since the Grutter case was that President Trump was elected and appointed three extremely conservative justices. Justice Kennedy and Justice O'Connor were on the court during the Grutter year term, and Justice O'Connor actually wrote the majority opinion in that case. So in terms of, so we've known, I think, realistically, that the end of affirmative action was probably coming. And it's already been ended in many states. Many states have made the decision politically, including some of the largest states, California and Michigan, have banned affirmative action in higher education well before this case was decided. So those schools have already been turning to other measures. to try to improve the diversity of their entering classes, including the racial diversity, without using race as a specific category. Unfortunately, the evidence that I've seen suggests that those alternative measures, while helping, are not as effective as race-conscious remedies. So, for example, socioeconomic affirmative action, giving a leg up for people who come from lower socioeconomic means, has the empirical studies I've seen have suggested that they primarily benefit poor white students, which is great. Also, it's a different kind of diversity, but it isn't achieving the same kinds of racial diversity that that race-conscious admissions have. Other schools have experimented with these so-called 10% programs, where so, for example, the University of Texas tried to use a program where if you graduate in the top 10% of your high school, no matter which high school you went to, you'd automatically be admitted to one of the University of Texas campuses. That also has been helpful, but not as helpful as race-conscious admissions for a variety of reasons, some of which DL has already mentioned. It's one thing to admit a student, it's another to provide the wherewithal to be able to attend the university and the support once you get there. So those have not been, again, they're well intended, and it's great that they've tried them. They just have not been as effective. I'm really interested in the adversity score program that the ironically, the University of California Davis Medical School was the defendant in the Bakke case, the very first affirmative action plan case. And they seem to be making some headway with this sort of set of criteria that show what burdens you have had to overcome in order to attend medical school, and for example, it's very children of doctors get admitted to medical school at a much higher rate than children of non-doctors. There are all sorts of other, there's legacy admissions. There's all sorts of other sort of barriers to improving the diversity in university classes. This is designed as a race-neutral measure of, so what did you overcome, right? Did you have to work to help support your family when you were in high school, whether, whatever, without regard to your race? Are you the first student in your family to apply to medical school? What are the things that you've overcome that many people just take for granted, right? I'm very intrigued that this seems to have been effective as a measure at UC Davis Medical School. But again, we'll have to see what the data sort of shows in terms of its actual effectiveness. And then on the other hand, you have the conservative legal movement threatening to challenge any kind of alternative program as basically a disguised form of racial affirmative action. And so we definitely have not seen the end of this. I think they've already sent up the flares to supporters, saying we're going to be vigilant in making sure that students don't or that schools don't circumvent this decision by using measures that are effectively race-based. The other thing I wanted to just throw into that is even the majority opinion acknowledges, as we've discussed, that race race can be discussed in your application. It's just not something that the universities can base their decisions upon, which reflects, in my view, a very unrealistic way of the way like we are as human beings. Like it's as if the majority says we can just disaggregate race from every other aspect of your background, and as long as we're considering the other aspects and not race, the universities are okay. That's just not realistic, right? I mean, race is an important component of who we are, just like many other factors. This came up in the oral argument. Justice Ketanji Brown Jackson asked the lawyer for the plaintiffs, so would it be illegal for a university to admit a student because they represented in their personal statement that they were the descendant of enslaved persons, right? Is that race neutral, or is that not? And so and I think that the lawyer had a lot of trouble answering that question, and rightfully so, because again, these things are integrated in who we are as human beings, who we are as what our lived experiences are. And it's just, I think it's fiction to suggest that those things can be disaggregated in the way that the court seems to think that schools should do now.
Thanks for that. I'll remind the audience, if you do have questions on your mind, please feel free to type them using the Q&A button at the bottom of your Zoom screen, and we'll try to get to those in a bit. Sarah, I was hoping to ask you a question. Alan had referred to some of the comments by our newest Associate Justice, Ketanji Brown Jackson. I want to ask, she had a rather impressive dissent in this opinion that said, among other things, I'm quoting here, quote, "The best that can be said of the majority's perspective is that it proceeds ostrich-like from the hope that preventing consideration of race will end racism. But if that is its motivation, the majority proceeds in vain," unquote. I'm curious, like, just in general, what kind of power or legacy does a dissent have? Like, what's its purpose? And in this case, what can we read into this about where things are going in the future?
Yeah, thanks. So I'm going to talk a little bit about the content of her dissent and what makes it distinct from some of the other ways the court has talked about affirmative action in the past, and then get to that question about dissents generally, sort of, do they matter? What do they mean? But Justice Jackson's opinion highlights this key debate on the court that I think extends much more broadly than this case, about the question of whether colorblindness as an approach to responding to racism and racial inequities is appropriate, realistic, based in reality. And what's interesting about this is that the court in previous affirmative action cases has really centered on this goal of universities of creating a diverse class. So in some ways, affirmative action is okay because it also benefits the white students in the classroom to have people of color also as part of their peer group. And although Jackson does discuss that diversity interest in her dissent, really the bulk of it is on the history of racism in the United States and the redress of real harms and discrimination, which the court has kind of shied away from in prior affirmative action rulings. So one of the things she writes is, quote, "Our country has never been colorblind given the lengthy history of state-sponsored race-based preferences in America. To say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry." And she then goes on to trace racially discriminatory policies all the way from slavery through the failure of the Federal Home Loan Bank Board to address racial discrimination in home mortgages through the 60s, and then discusses how race-conscious government action and inaction can be directly linked to present-day racial inequities. And she also notes this long history of race-based admissions, writing that for most of US history, Black students had no chance of being admitted because college admissions were race-based in the sense that if you were Black, you just couldn't be eligible at all to be admitted to many universities. And she says, and again, she's writing here just about the UNC case, but that whole, quote, "holistic programs like UNC's reflect the reality that Black students have only relatively recently been permitted to get into the admissions game at all." And so sort of as Seth mentioned in his intro to this question, she argues that in ignoring that reality and all of this history, the majority opinion is only delaying efforts to achieve racial equality. And this really comes back, I think, to this core debate on the court and in society of a colorblind constitution versus race-conscious practices much more generally than just in college admissions as a way to redress past and current discrimination and racial inequities. In terms of dissent generally, I always go back when I'm talking with my students about this to a quote from Justice Brennan. He was famous for saying, quote, "5 votes can do anything around here." And once conservatives got 5, in this case 6 votes to reverse previous decisions on affirmative action, whether they want to call it overruling or not, they did that. And I would expect the same to be true with this dissent and in the opposite direction, that as long as liberals remain in the minority on the court, Justice Jackson's words are powerful rhetoric, but are not going to change the direction of court rulings without some change in the court's membership.
Just as a follow-up on that, I mean, do dissents sometimes find their way into majority opinions later on when there is a shift?
Yeah, so I certainly think ideas and concepts from dissents can find their way into majority opinions later, but I think that's more so based on that membership change in the court or some other shift in the court's reasoning beyond just, oh, that person was really smart and persuasive, which this dissent is, but I don't think that's going to somehow lead to some change of heart in the conservative majority on the court.
Okay, thanks so much. That's really helpful. We actually have received a question from an attendee who says that they would like to hear more about the research around institutions considering socioeconomic determinants in admissions and how those largely only benefit white, low socioeconomic level students. Why is this? If anyone is familiar with the research on this, have any interest in weighing in on this?
All right. I know that I don't know that the studies go so far as to explain the reasoning for this is just sort of a results-based analysis in terms of the comparing before and after socioeconomic measures were implemented and what the composition of the entering classes look like. I don't. DL might know more about the nuts and bolts about why this happens, but I actually don't.
I think it's really at bottom, which has now become like my favorite phrase to use ever. At bottom, it's littered throughout Justice Sotomayor's dissent. But it's a numbers. It's really a numbers issue. So the number of people who are in these pools are actually not majority people of color who are low SES, right? And so by default, the majority of the people who are in the pool are actually white and low SES. And so therefore the programs end up benefiting them just simply because there were more of them to begin with in the first place.
Thanks for that. Here's an interesting question that just came in. What is exactly the infrastructure for enforcing this decision by the court? That is their ruling, will it be enforced through lawsuits? Does the Department of Education have some role or responsibility in actually enforcing it? Alan, is this an area you're familiar with, or?
Sure. I mean, there's multiple dimensions of how this is going to be enforced. One is just going to be voluntary compliance by universities across the country because they don't want to be sued, and they don't want to sort of go through the expense of fighting a lawsuit on these issues. The Department of Education question is an interesting one. As I mentioned, Title VI of the Federal Civil Rights Act basically prohibits discrimination by any recipient of federal financial assistance for higher education, and so which applies to the vast majority of public and private universities. The question of whether the Department of Education would go after a school to say you are using race-based affirmative action that violates Title VI, therefore we're going to rescind your funding. That's really a question of political will and who's in charge of the White House, I think, in terms of whether that would happen. So I think that's more of a political decision than it is a legal one, but technically that's how they would go, how the Department of Education would go about enforcing this.
Thank you. Well, we're getting lots of wonderful questions in here. Okay, here's another one. Does switching over to pointed essay questions mean that prospective students will need to be able to clearly demonstrate the kind of oppression that they've faced? So, and this person goes on to say, imagining an applicant who would bring a truly unique perspective to a classroom at a place like the University of Denver, but who at just 17 years old very reasonably might not yet even fully recognize or know how to articulate how something like race has affected their life or how it's played a role in their lived experience.
I can take a stab at that. I think this is a real concern, and this goes back to the line in Robert's opinion, right, of saying that schools could still take into account individualized experiences. And then he goes on to note, though, that schools can't use that as sort of a proxy for race or a proxy for affirmative action. It has to be really based on their individual experience with regard to race in their life. And I think generally, and DL, maybe you can say more about this too from a higher ed perspective, I think something we know is that essays are something that if you are more well-resourced, wealthy, you can hire a college counselor to help you write and revise and perfect that most perfect essay. And other students obviously don't have access to those resources at all in terms of paying someone, but also in terms of a family member who could help them sort of craft that essay. So I think it's about, as the question mentioned, sort of that self-realization of the role race might have played in one's life and lived experiences, and also the ability to communicate that in a written format, and the very highly differential resources that students would have access to in being able to craft that type of essay. So although Roberts does leave open this door, and I think colleges are going to be looking at that very carefully, I also think it has some definite downsides and drawbacks to it.
I couldn't agree more, Sarah, and I appreciate the volley. Also to chime in here, there are two other things that come up for me that are of concern around this question. Is one of them is, how are we inviting young people? So yes, the typical student who's applying at any of these one of 200 institutions likely is going to be coming directly from high school, secondary school experience, likely will be somewhere 16, 17, 18 years old. And because of that, I'm thinking in two things. One is about what sometimes has been called in certain spheres trauma porn, and the ways that we're asking young people to just get enmeshed and vomit out all of this trauma in order to get into college. And the equity of that, is that really equitable? Does that have meaningfulness to it in a way that is not harmful to that applicant? To do that. And the other thing is about the self-reflexivity. Is it developed enough yet to be able to put together, I went through this experience, this is the impact it had on me, this is what I'm able to do now because I've had this experience, and my outlook on the world now is this, right? That's a lot of work to do cognitively, psychosocially. That's a lot of work to expect from someone to do. Doesn't mean they can't do it, right? But then you do have, as Sarah said, those differences in resources of who's going to be able to shape an essay and shape an essay, right? To be able to do the work that gets the check mark, like, yes, this is a strong essay, because it also shows strong writing skills too. It's so yeah, I mean, it's not it's not without jeopardy to go into that direction at all.
Yeah, if I could just related to that, we've got another question here. You talked to DL. You talked about the problems of like adversity porn. Just people just sort of spilling their guts about everything. Could it also be a situation where we might just simply have people inventing adversity in their lives? And the college application essays are obviously very difficult to police. And we have had some scandals in recent years where, people just simply invent things. I wonder, is that a concern in this area?
Sure. I mean, and it's a concern, and it's no more of a concern now than it was before this decision, right? Because people, like you mentioned, Seth, there have been cases where folks have falsified information in their application essays, right? People, that has already been happening. So we shouldn't pretend that all of a sudden now it's going to happen at some dramatic number increase. In light of this, is artificial intelligence. I mean, we could also be asking, is ChatGPT now going to be asked to write the adversity score, the adversity essay? Yes, there are going to be some people who are going to try to do that. Usually the people, I would suspect, my hypothesis is that the people who would go those routes to try to game the system are folks who wouldn't have benefited from race conscious admissions. And they're now trying to find a way for them to be able to benefit in a system in the absence of race conscious admissions. So
can I add just one quick point? I think somebody mentioned earlier one of the dangers of this opinion, I think, is that somebody mentioned earlier that the universities might be particularly gun shy and sort of say, well, we don't want to be sued. So I think DL made this point. So I think the same thing could happen with students, right? I actually am afraid to present my personal experience because it sounds like I'm focused on race, and the Supreme Court just said that they can't use race in admitting me. So I better just leave that out of my essay altogether, right? Even though it might be a relevant experience, an important one. So even aside from the other concerns that have been raised about this issue, the signal that the court sends with this decision, where you read the headline saying, no, affirmative action, no more, right? Might be that the students will say, well, guess my race doesn't matter. My experiences don't matter. I'll write about, my experience in the debate club or in sports or something else. And that, I think, is an unfortunate side effect of this petition, because we're actually going to know less, or we could know less about our applicants instead of more.
Thanks for that. Got another question in, and I'm curious if we know enough about the decision to say what the effect would be here. But this question is specifically about the University of North Carolina, which has quotas for admission by county. And that does consistently lead to admissions by students not as traditionally ready for college as those in some other counties. Would the current majority or would the current ruling repeal quotas like that sort of thing? Do they seem are they more inclined to limit things to race-based admissions alone, or these sorts of county level admissions as well?
Alan, do you want to?
No, you go ahead, Sarah.
Yeah, I mean, certainly we don't know for sure. I'm sure there'll be lawsuits about it. I guess the line I would point to from the decision is where Roberts talks about colleges not being able to use proxies for race. And so I think it would probably turn on whether the court believes whatever sort of geographical quota. We talked earlier about University of Texas using this high school. If you're top 10% of your high school, that'd be a similar sort of model that's not race-based, but is based on patterns of racial segregation to achieve a more diverse class. So is the court going to consider these types of things that are ultimately based on residential segregation as proxies for race or not? I think it's wait and see. I don't know if I trust this particular court on that issue, but I don't think we'll know until those cases come through. I do think more broadly, I won't be surprised if we see lawsuits around affirmative action outside of the college admissions process, just in sort of in other areas of the economy. So that's the one I might more expect to see next.
I would just quickly add that under the Supreme Court's equal protection doctrine, challenges to racially neutral policies that have a disproportionate effect on one particular racial group are not subject to strict scrutiny, generally, unless the plaintiff can show that the government made the decision to specifically harm a particular group. So a race-neutral county, regional affirmative action program would actually be easier to defend, at least under current law. But if Roberts is trying to signal that the proxy issue leaves that open to revisitation, then again, all bets are off with the current court.
We have another question that's come in. I think we discussed earlier that the Supreme Court's latest ruling applies to admissions and not to funding or scholarships. But there's a question specifically about Georgetown University's reparations fund, which, as I understand it, is designed specifically to benefit students who are descendant from enslaved peoples. Does this ruling affect that? Do we see something like that in the Supreme Court sites or anything like that in the near future?
I'm afraid the answer is yes. I hope it's not, but I don't know how under this system, under this holding, that the universities will be having to defend those programs as well. The only thing that I could say that suggests a potential positive note on this is the court does has in other contexts said that race can be taken into account to overcome past what they call identified discrimination, which means discrimination by this particular institution. And so if Georgetown says, here was our pattern, right? We benefited from, from this economic system of enslaved persons, and now we're trying to directly remedy the past effects or the ongoing effects of that past discrimination. They might be able to justify it on that ground, but I do actually foresee challenges to financial aid programs that are race-based after this decision.
And a challenge forthcoming does not mean let's overcorrect and stop it now before the challenge comes, right? I mean, I think we need to, as higher ed, persist in doing what we're doing until someone tells us we can't, and then we need to find a different way to do what it is we were doing until someone tells us we can't do that either. I mean, we must persist. Right? We must persist and not shrink back in anticipation of what may very well be coming.
I agree 100%.
Really good point, DL. Thanks for that. Had another question here. So actually, shortly after the decision came out last week, Republican Senator Tim Scott of South Carolina, who is running for president, said that schools should now also get rid of legacy admissions, by which schools give admission preference to basically the children of their alumni. Do you all see this as something that's on the table? Is this something that could become a Supreme Court case that the government could banish, or is this more a decision for individual schools? Is it something worth trying to banish? Curious if folks have thoughts on that.
Isn't there already a suit that's been filed? Alan? Yeah, Alan's not in. I'm gonna go ahead and turn it over to you to talk about that because it's coming. Sarah. Alan.
Yeah, I haven't read all the details on it, but there is a lawsuit against Harvard challenging legacy admissions. There also have been, I believe not in this session, but in the prior legislative session, a law introduced in Congress to try to ban legacy admissions. I guess what I would say is I'm all for it. I think legacy admissions are fairly ridiculous. I don't think it's going to solve the problem that this case created. I think it's a good policy to do on its own merits. I don't think it's going to solve the issue of banning race-conscious admissions practices that's raised by this case. So yeah, I don't know if you want to chime in on that as well, Alan.
So I just quickly, the lawsuit that was filed basically asked the Department of Education to open up an investigation of legacy admissions as a violation of federal law. So so going back to the question, what's the role of the Department of Education here? That may be something that they interrogate closely. And but I agree with Sarah that this is not. I think it's good policy, but it's not going to enhance diversity, racial diversity in any significant way. Interestingly enough, Justice Gorsuch, no friend of affirmative action, in his concurring opinion, actually sort of took the universities to task for legacy admissions and saying this is no better than what you're doing with race. And so he actually expressed a strong opposition to legacy admissions.
Thanks so much for that. I think we have time for just one more question. And we received another one that's just asked, do we know what universities and school districts are doing to help educate juniors and seniors on what this decision actually means? And how, if a student wants to discuss their race, they can. DL, I'll start with you on this one, but if others have thoughts on it, I welcome you to chime in.
Sure. It's so soon, right? That I don't know that anyone has gotten in front of this, although perhaps the writing, as we've said earlier, was on the wall that perhaps people could have been thinking proactively to start doing these things. But I would hope that universities and other college adjacent organizations that help support college access particularly for underrepresented minority students would be doing exactly that. Coming alongside to help support guidance counselors in high schools that are typically overstretched, to help provide concrete information about what the decision actually is, what it actually means for that student, for those students, and how they can work with the opportunity before them in their application essay or essays. In some institutions, you have to write more than one, to be able to bring forward and to help do in response to go back to the question that was asked earlier about the self-reflexivity, really, of students, to help support these high school students to be able to do that, junior high and high school students, to get this, to be prepared for this, because it's not going away anytime soon, if at all. And I do hope that universities will be invested in their communities enough to reach back and to reach down and to help provide that kind of support.
Okay, thank you for that. So I think we're basically out of time at this point. This has been a really interesting discussion, and I really appreciate our panelists for bringing all this information in here. I want to thank Megan Grogan and Katie Aker for helping to set up our discussion today. I hope you all will thank me or join me in thanking our panelists, Sarah Chatfield, Alan Chen, and DL Stewart. Thank you all for attending and for your wonderful questions, and I hope everyone has a good week. Thanks so much.